Hi, I'm the first presenter. My name is Cynthia Japuri Analipa. My metric number is 20TAT24F1017. For question 1, Azrin, who carried as an accountant for more than 3 decades, has been employed as a director of Smart Invest Berhad, a public investment company. In discharging one of her main duties, she is required to prepare the financial statement according to the basic standard guidelines and framework. Azrin, however, has neglected prepare such document when it involved a series of major misstatements and miscalculation. This would never be expected from Azrin, who was deemed to have vast experience in the said practice. Following a huge loss and setback, the company had dismissed Azrin and sued her for damages, advised Azrin accordingly. So the issue is whether Azrin can be sued and dismissed from the company for her damages. This is under section 165 of the Contract Act 1950, skill and diligence required from agent. An agent is bound to conduct the business of the agency which as much as is generally possessed person engaged in similar business unless the principal has notice of his want of skill. The agent is always bound to act with reasonable diligence and to use such skill as he possesses and to make compensation to his principal in respect of the direct consequence of his own neglect, want of skill, or misconduct, but not in respect of loss or damages which are indirectly or remotely caused by such neglect, want of skill, or misconduct.
My name is Patricia Sandok Anak Mingge. My ID number 20DAT24F1025. So I'll be presenting one of a similar case, which is Keppel versus Wheeler 1927. So this case is a dealing English contract law case that deal with misrepresentation and the duty to update material fact during negotiation. So basically, Keppel was a buyer interested in purchasing a property. Wheeler was an estate agent who was representing the seller. One day, Keppel made an offer which the agent accepted on the seller's behalf. A higher offer came in afterward, but Wheeler did not inform Keppel. Unfortunately, the seller accepted the higher offer instead, which allowed Keppel sued for the damage. Here comes the court decision. So the court held that Wheeler, the agent, had a continuing duty to update Keppel. The failure to do so amounted to a misrepresentation by omission. Hence, the judgment was in favor of Keppel. Therefore, in conclusion, Azrin can be sued and dismissed for her damage because she failed to carry out her duty to prepare financial statement according to basic standard guidelines and framework. She negligently prepared the document, resulting in major misstatement and miscalculation. In applying the case of Keppel versus Wheeler 1927, the agent failed to disclose their personal interest in the transaction, breaching their duty to act solely in the best interest of their principal. Similarly, Azrin, as a director, has a duty to act with reasonable care and skill in preparing financial statement. In applying Section 165 of the Contract Act 1950, given that Azrin's negligence directly led to financial loss for the company, a court would likely find her in a breach of the duty.
My name is Kathleen Emianapo. My ID number is 20DAT24F1009. So today I want to present question 2. So question 2 is about Reza. So Reza, he wanted to sell his Range Rover to get some money. So on 15 March 2025, he met his old friends who is Lina. So Lina said Lina would buy the car. So However, so Reza believed her and gave her the car right away. So she promised to pay by the 1st April, but she didn't pay even by 1st May. Reza then realized Lina had cheated him. So when he tried to take the car back, he found out that Lina had already sold it to someone else, a man that named Salim. So Salim bought the car honestly and didn't know anything about the problem. Now let's look at the legal issue in this case. So the main question we need to ask is, does Reza still have the right to take back the car from Salim? So Reza gave the car to Lina because he trusted her to pay later, but Lina cheated him and sold the car to someone else. So Salim bought the car honestly without knowing anything was wrong. So the issue is whether Reza can still claim the car from Salim even though Salim is an innocent buyer. So according to Section 30, subsection 2 of Sale of Goods Act 1957, where a person having bought or agreed to buy goods obtained with the consent of the seller, possessions of the goods or the document of title to the goods, the delivery or transfer by that person or by a mercantile agent acting for him of the goods or documents of the title under any sale, pledge, or other dispositions thereof to any person receiving the same in good faith, and without notice of any liens or other right of the original seller in respect of the good shall have effect as if such liens or right did not exist. So, according to this section, if a buyer receives the goods with the seller permission and then sells them to someone in a good faith, the original seller cannot take the good back, even if the buyer hasn't fully paid. So, applying this to Reza case, Reza have possessions of the car to Lina with his consent. So Lina sold the car to Salim. Salim acted in good faith and had no notice of Reza's rights. So under this section, Reza lost his right to claim the car back from Salim, even though Lina never paid it. So, conclusion is, Reza cannot take the car from Salim. His only option is to sue Lina for fraud and claim damages.
Hi, my name is Chis Anna Monica and my metric ID is 20D8024F1029. So this is the case fact similar to the case given, which is Newton Willie Limited versus William 1965. The plaintiff saw a charge to appellant who paid by check. Although he was given possession, it was agreed that the property would not pass until the check was dishonored. The check was dishonored, but appellant had resold the car to buyer who bought it without knowledge of the possession. Buyer resold it to the defendant. The plaintiff tried to recover the car from the defendant. So this is the court decision for the case fact. The High Court held in favor of the appellant. The original buyer was in possession with the consent of the owner. Hence, he could pass a good title to the buyer, who in turn transferred it to the defendant. The defendant was therefore entitled to keep the car. Now we are moving on to the conclusion. In the conclusion, Lisa has no right to reclaim the car from Salim, as Salim purchased it in good faith and without any knowledge of Lina fraudulent conduct. This position is supported by the case of Newton of Willie Limited versus William, 1965. In that case, the court held where the appellant had not yet obtained ownership of the car due to the dishonor check. He had no right to sell the car to another party. Therefore, even though the buyer and defender in that case acted in good faith and were unaware of the whole transaction, the original seller was still entitled to recover the car. This case reinforces the principle that possession alone does not grant a person the legal right to transfer ownership unless the debtor has lawfully passed. Therefore, under Section 30, Subsection 2 of the Sale of Good Act 1957, if a buyer purchases good in good faith and without knowledge of any defect in the seller debtor, that buyer is protected. As such, the original owner cannot reclaim the goods. Applying this to the current case, Lisa cannot reclaim the car from Salem, as Salem was an innocent purchaser who acquired the vehicle in good faith.